Welcome back to Australian Patent News. Today, Nick will be having a look at international patenting strategies. Fidel will be talking with one of our clients about his new exercise device innovation. And John Baxter will be talking about international licensing strategies.
I'm here with Baxter IP client Allan Conen, who came to us with his exercise device innovation. Allan, you want to tell us about your device?
Yeah, certainly, Phil. Thanks. Yeah, look, it's a bit of an involvement, really. We first started with the fender, which is actually a boat fender, which they throw over the side of boats. So obviously it's very durable, very hard device.
Okay, so it's to stop the boats from hitting the pier and hitting each other. Yep.
That's correct.
Okay.
Yeah. So from that, there was a product devised, which is called this product here, which is quite a large. It holds water and air.
Okay.
When this was devised, they obviously devised it with strapping component. The straps, I found what happened to them once they got wet, they started to slip off and so forth. There's the product size as well was very hard to use because the weight of it, nearly 30 kilos and so forth. So I actually brought it in for my rugby team. The rugby team found themselves, under 16s, they just couldn't use it properly.
Just a little bit too heavy.
Yeah, they could do the odd one, they could do some squats and a few things with it, but just too heavy and too hard for them to use.
Okay.
So what I did is I looked at that component there and I thought, well, ideally, what could we use in relation to improving that? And I thought, well, obviously some dumbbell situations.
Okay.
So I developed these. We call them grenades. What they are is a single like dumbbell type exercise device.
Okay.
Put molded handles on to solve the problem with the straps situation. So a permanent fixture there. Again, we fill up half water, air, or completely with water, which gives you about 7 kilos.
Okay.
But of course, and very hardy, so you know it's a terrific product. And going from there, I developed the ones into what I call torpedoes.
Okay.
Now these ones here, I found are manageable. Females can use them comfortably, and yet going up to about 16 kilos, extremely good. An unstable exercise device. Yeah.
Okay, so by unstable you mean there's a combination of air and water in the inside, so it's not fully filled?
That's correct,
Okay.
yeah. So what happens, obviously, once you move the device from one side to the next, water moves across, straight away, unstable, you've got to react with your body, so really attacks the core of the body.
Oh, excellent.
Yeah.
So what's the main advantage of a device like this as opposed to, say, a barbell or a kettlebell?
Well, firstly, they're user-friendly. As far as barbells and dumbbells concerned, steel. Younger people using them, elderly, so forth. They're not as user-friendly. It's a lot harder to get up in the morning and pump some steel than it is to these. Very user-friendly, so there's no danger with them. The one set themselves, you can put as many different weights in as you like. So you can weight this at 2 kilos, 5 kilos, or 7 kilos.
There's a whole lot of flexibility in the device.
Very much so, yeah. That's the wonderful thing about it. Between the torpedo and the grenade themselves, you can literally do any exercise a dumbbell, barbell, the Viper or kettlebells can do. So you can do the whole lot just with the set.
Excellent. So how is the product doing commercially at the moment?
Well, it's early days yet, as you know. It's only been a few months, but at this stage we've had some very positive feedback.
Excellent. Yeah.
Shown it to a couple of major franchises, and they're very excited about the product. I've also been approached by a couple of magazines also for editorials and major spread in their magazine.
Excellent. Do you have a website for further information on your product?
Yeah, certainly. Yeah, it's www.nzone.com.au.
Okay, thanks very much for coming in today, Allan. And to find out more about this product, go to that website, nzone.com.au.
Hi, I'm John Baxter, one of Baxter IP's commercialisation advisors. And over the next few minutes, I'm going to share with you some of my insights into commercialising patents by licensing. It's best to think of the structure of the basic rights being granted by the licensor to the licensee as a matrix of parameters. These should include, firstly, whether the licence is exclusive, non-exclusive or a sole licence. The important question here is whether there will need to be other licensees, now or in the future. A sole licence is generally accepted to be an exclusive licence. except that the licensor retains commercial rights to exploit the technology in its own right. Secondly, will the rights being granted be for manufacturing, usage or sales, or a combination of these three? How will a licensee be limited in terms of how it makes use of the IP? Remember that in the broadest sense, the monopoly provided by a patent is to manufacture, use and sell. The next important issue is a geographical territory or territories. In which countries will a licensee be allowed to commercialise the IP? Next, the application field, or a definition of the licensed product or licensed process is needed. Will a licensee be limited in terms of the types of products or processes which is able to use the IP in relation to? Generally the answer is yes, because patent claims, by their very nature, are written in order to maximise broadness in the context of the existing prior art. Next, you need to define the actual IP being licensed. For example, granted patents, patent applications, registered designs, common law trademarks, documented know-how and undocumented know-how. Remember that any know-how to be licensed should ideally be fully documented and listed in summary bullet point form at the very least if this is not possible. And finally, are sub-licensing rights or have-made rights going to be granted? The question here is whether the licensee will have the right to license others. If so, under what terms? Will the licensee have the right to subcontract the manufacture of the licensed product? You can see here it's very important to think of the rights granted in terms of a matrix of these parameters which I've just mentioned. For example, exclusive manufacturing rights may be granted under a certain set of IP in the United States. But for this same set of IP, non-exclusive sales rights could be granted for the rest of the world. IP relating to hydraulic system may be licensed in one territory for earth-moving equipment greater than 10 tonnes, and that same IP licensed for another application, for example materials handling or forklift trucks, less than 5 tonnes in another territory. You can be specific as you need to be here, providing the definitions are completely rigorous. Such limiting definitions, of course, are of particular importance where exclusive rights are being granted.
Hello, my name is Nicholas. I'm a patent attorney from Baxter IP Patent Attorneys. Today I'm talking to you about strategies in international patent protection and different strategies to get patent protection in countries around the world in alignment with your commercialization strategies. All right, so to start, let's just clarify one thing. There's no such thing as international patent protection. At the end of the day, you need a patent in each country of interest. So I'll be taking you through the patents pipeline to show you different strategies to conduct the protection of your intellectual property, generally in accordance with your commercialization of your invention. All right, so this is the pipeline. It lasts 20 years. That's the term of a standard patent. It's got 3 main stages, as I've shown in different colors here, starting with the provisional stage, and then the international stage, and ending off with the national stage. Now you can see that the national stage is where you file patents in each country of interest. However, the way you should go about protecting your invention is by starting off by filing a provisional patent application. What that does is that gives you an international filing date, which means you have the option of going into these countries down the track depending on how your invention is received in the market. So what usually happens is you engage a patent attorney to prepare a patent specification. The patent specification must be a technical description of how your invention works, and it's very important that the technical details go into the patent specification because you're only given a filing date for what you describe in the patent specification. All right. So if you describe features A and B and C, you will only get an international filing date for those 3 features. If you've omitted a feature, such as feature D, you will not be given a filing date for that feature. So the take-home message is it's very important to go into a lot of detail in the initial filing of your provisional patent application, because that's the specification you'll be relying on for the 20-year term of your patent. The provisional period lasts a period of 12 months. What that 12 months gives you is actually 12 months to commercialize your invention and to see whether it's got legs. So what happens is you file your patent application for your invention at the beginning of the provisional period. And then you've got 12 months to approach investors, to maybe manufacture your invention, start making sales. Because at the end of the provisional period, at the end of the 12-month period, you must make a decision as how to continue with your application. If it was well received in the market, you may go for a more aggressive patent prosecution strategy. If it didn't do so well, you may file in just your major countries of interest, or you may just let the provisional patent application lapse. The advantages of filing a provisional patent application are that the technical description of your invention is never published, so your competitors can never see what you've done if you stop at this point. It also is a great period for capturing improvements to your invention. So say 4 months down the track you come up with feature D. What we can do is file another provisional patent application to capture that feature and to get a later filing date for that feature. So at the end of the provisional patent application you've got two choices. One is you can file an international patent application, which is referred to as the PCT application, or you can dive straight into your countries of interest. Well, basically by filing an international patent application, you're keeping your option open for pursuing patent protection in your countries of interest by a further 18 months. All right? So basically, from the filing of a provisional patent application to filing in each country of interest gives you 2.5 years, which is a great amount of time to commercialize your invention, find investors and the like. So for example, say some stage during the international stage, you get an investor who's looking to invest and has given you a lot of capital to pursue patent protection around the world. You may decide to file in a lot of countries around the world. If you had omitted the international patent application stage, you would have filed in each country of interest. Say for example, you had filed only in China and Australia. By doing that, you would have lost your rights to go into the United States and Europe, for example. So we always recommend clients go down the international route because it gives you a further 18 months for which to choose which countries to pursue patent protection in. So one of the questions we get asked often about by clients is, how do I know if my invention is new? All right, so there are a couple of strategies you can do to find out whether your invention is new or not. One of the advantages of filing a provisional patent application is we can request what you call an international type search. Now, an international type search is done by the International Searching Authority to find out whether your invention is new or not. So what happens is you file a provisional application and then you request an international type search. And the examiners at the International Searching Authority will search your invention and come up with one or more documents to let you know whether or not there's any prior art that's relevant for your invention. One of the great advantages of requesting an international type search, especially if you're going down the international route, is that during the international route, the examiner performs a search and they issue a written opinion. If you've done the international type search at this point, you know what prior art documents are going to be cited against your application down the track. As such, it can be a matter of distinguishing your invention before filing the international application so that your application proceeds through without hinder. Okay, so in conclusion, we've learned today that there's no such thing as an international patent, and that you need a patent in each country of interest if you were to assert your rights in that country. So the way the patent pipeline is staged is that you don't have to choose your countries up front. The way you can protect your invention is you can file the provisional application, and then as you commercialize your invention, you can decide where to take your patent protection. So if you've got any questions about international patent protection, feel free to contact us at Baxter IP Patent Attorneys. We can suggest strategies for protecting your invention that's closely aligned with your commercialization of your invention.